Hi, I'm Judge Dick Klein. Thanks for the opportunity to let me talk to you. I'd like to share my experience in the do's and don'ts of oral argument. In my career, I've been listening to lawyers argue to jurors and to the court for 40 years. 26 as a trial judge, 8 on the Superior Court, and now 10 as an arbitrator and mediator. Too often, lawyers forget to organize their presentations and plan strategy. In addition to serving as a mediator and arbitrator, since leaving the bench, I'm often retained as a consultant for appeals and also post-verdict motions. What has surprised me is that many of the people that come to me are the top appellate lawyers in the area, not just those who are filing their first appeals. These lawyers recognize the need for a fresh, independent viewpoint. I can use my experience as a judge to help them hone their arguments to judges, whether by hearing their arguments in a mock format or by reviewing and analyzing their briefs and coming up with strategies to organize the oral argument. I'm co-author of the trial practice book, Trial Communication Skills, written with the guy who wrote the first body language book, Julius Fast. One of the things I preach is that in any communication, you must think of your audience. This advice is particularly true on appeals and also post-verdict motion arguments. The communication there is different. Even if a judge hears the trial non-jury, he becomes a different audience on post-verdict motions. You've got to remember that you can't retry your case on appeal. On appeal, the courts see their role as correcting mistakes. So it doesn't matter how much your client was injured or how much the jury got the facts wrong. On appeal and on post-verdict arguments, the question that concerns the judges is whether the law was followed and the rules were followed. At the same time, it's probably a good idea to subtly make the point that justice is on your side. While judges see their role as following the rules and correcting mistakes, sometimes they can find creative ways to bend these rules if you indicate that to them that you're on the side of truth and justice. Also, both in briefs and oral arguments, use a rifle, not a shotgun. Don't argue multiple issues. Pick the ones that are strongest in your favor. Next, remember that your case is not the only case that the judge has to decide. It may be the most important case to you, but it probably isn't for the judge. You've got to keep things crisp and concise. For example, if you're the appellee and you've seen the judges beat up your opponent in his or her argument, your best argument may be, I think the court understands the issues. I'll rely on my brief unless you have any questions. Welcome questions and prepare for them. For example, if you're allotted 15 minutes for argument, you only should prepare for 5. The rest of it will be taken up by questions. And in preparation, think of the questions that may come your way. Where I add value in conducting a mock argument is to think of every possible nasty question I can and then pepper you with them. It's much better to be embarrassed if you don't know the answer to a question when you're in a mock argument than it is when you're arguing before the court for real. With all due respect to Allen Iverson, practice is important. Hard as it may be, don't wait until the night before your argument to practice it. And as I said, make sure you practice answers to questions as well. It's best to get somebody from outside to grill you, but one way or another, run through the questions you might be hit with. You also may want to ask, do I have the experience and expertise to go to oral argument without some help? The top appellate lawyers think I can add value by giving to them the perspective of the audience, which in arguments is the judges. If you think I can be of assistance, don't hesitate to call me on my cell phone during the pandemic or email me. Thanks so much for listening.